To discuss the issue, we have with us Dr. Amit Sengupta from the Swasthy Abhiyaan. Hi Amit, and thanks for being with us today. Now, why has this working group been set up and what is its mandate? I mean, there appears to be a lack of clarity over the terms of reference for this group. So what will this group actually look to achieve? And will it actually have the power to change or agree to changes in the Indian patenting regime?
See, many things are not clear at the moment, but what is rather ominous is the chain of events that have led to the setting up of this working group. Just before Prime Minister Modi was to leave for the US, we had Commerce Minister Nirmala Sitharaman making a statement just off the cuff, and there was no context really, saying that India doesn't have an IP policy,
right,
and that we need to create a new IP policy. The new government is working on that. Now, that obviously signaled the fact that this government is looking at ways in which to change the existing consensus around intellectual property that has across party lines existed for almost 2 decades. I mean, even before the TRIPS agreement was signed. And the consensus was that given India's priorities and stage of economic and technological development, we need an IP policy which should promote India's priorities. So, we have not deliberately in our IP laws put in provisions which ask for high standards of IP protection. Now, the fact that the government is talking about relooking the IP policy, so it doesn't make sense when the Commerce Minister says we don't have an IP policy, we have an IP policy. Yeah. So, obviously what she is saying, and not in so many words, is that the present government does not agree with the consensus. Now, this was followed up by Prime Minister Modi's visit, and then one of the outcomes of the joint Obama-Modi statement was the formation of the IP working group. Yeah. Now, from the nebulous reports that have come out regarding the IP working group, it seems that it is going to have what they call decision making powers. So, it is not just a consultative mechanism which they have claimed later. The government has claimed that there is nothing much to be read into it. It's a consultative mechanism. We wish to know what the US wants out of us. Now, you don't need a special mechanism for that. For 35 years, India has been on the watch list of the USTR. Right. And in detail, every year, they produce a report saying what they don't like about India's IP law, and it's precisely this, that especially in the area of pharmaceuticals, but also in the area of copyrights related to music, related to software, etc., they have been demanding higher standards of protection. So, what this kind of a working group would actually accomplish is not clear, but what is worrying is that it says that it will have decision making powers, which means that it infringes upon the powers of Parliament to actually make policy. Right. And as I was saying earlier, India's IP laws have been a product of a prolonged debate given India's priorities and interests.
Now, given that India, as you've mentioned, has consistently sort of maintained that its IP regime has been TRIPS compliant and that these TRIPS compliant flexibilities are there to benefit a large mass of our population, does this setting up of the working group, the fact that Nirmala Sitharaman has made comments as you just mentioned, does this indicate a weakening of India's stance in any way in the international arena?
Of course, it means a shift in India's position. Now, what actual shape that shift is going to take is obviously something that we'll only know in the future. But it is important to understand and underline that, for example, in the area of pharmaceuticals, it is not only an issue of Indian patients being deprived of low-cost generic medicines, but India is seen as the lifeline for patients, poor patients across the world, and not just in low and middle income countries, also in developed countries. It needs to be also underlined that even in the previous government, there have been voices which have started sort of saying that Indian IP laws are not consonant with the kind of neoliberal reforms that the economy is moving towards. What I think is happening is the present government is removing the fig leaf of legitimacy provided in the Indian Patent Act in terms of health safeguards that the previous government, in spite of all the neoliberal reforms, was maintaining. They are trying to discard that and trying to align India's IP laws with its overall neoliberal economic policies.
Now, this is something you just touched upon. I mean, but the wording of the statement announcing the setting up of this working group directly links the prevalence of a particular type of IP regime to economic growth and innovation. I mean, do you actually think that this correlation is correct and directly established?
See, this has been repeated ad nauseum by advocates of higher IP protection, that if you have IP protection, you'll have more innovation, you'll have more money coming in, etc. There is absolutely zero evidence that this actually happens. In fact, there is evidence to the contrary. There is evidence that, in fact, all countries have had lower standards of IP protection when they were playing catch up, in the sense that when they were trying to catch up with existing developed nations, both economically and technologically. The US, if you really look at IP protection in the US in the late 19th, early 20th century, they had actually low standards of IP protection because they were trying to catch up with Europe at that time. Right. You had Japan doing the same thing later in the 20th century. You have the so-called Southeast Asian success stories, Taiwan and others doing the same thing. So there is in fact evidence that countries have done best when they have aligned IP protection with their stage of development. So you cannot have IP law that is like one size fits all. Now, what the 1995 TRIPS agreement did was it tried, contrary to indications that existed, harmonize IP laws across countries. The only saving grace was that it also allowed what were called the flexibilities or the health safeguards. What is now being played out really is an attempt to even get rid of those flexibilities, even though the TRIPS agreement remains. If countries like India start removing these flexibilities, you really then have the same harmonized high standards of IP across the world.
And actually something I think that it also makes a difference to is the fact that you have a lot of other smaller countries, particularly in the global south, in South America and so on, who want to emulate the sort of regime that we have in India, but will be discouraged if we go away from this sort of...
Absolutely. Like, for example, Section 3D of the Indian Act. Now, there is a lot of interest in several countries in the south of trying to put in language similar to 3D in their own patent legislation. So, we have this peculiar condition where you have on one side not just civil society activists or health activists, but even country governments saying that the Indian Patent Act is a kind of a model act for low and middle income countries, and you have an Indian government which is starting to say that we don't agree with our own act and we need a different act.
Do you think this fits in well at all with the Make in India program, given that it's going to have an adverse effect on generics, which, as you mentioned, are providing a huge quantity of drugs for India, manufacturing here and earning income for our country?
No, I think it makes absolute sense. It links very well with the Make in India campaign. See, it's interesting. It's not a Made in India campaign, it's a Make in India campaign, which means that you are inviting all and sundry from across the world to use India, to use Indian personnel, to use Indian infrastructure to make goods which they can expatriate out, which profits that they can expatriate out. And in fact, for a Make in India campaign of this kind, they would love an IP regime with higher standards of protection so that they can repatriate higher profits.
Now, the DIPP has claimed that the setting up of this working group will actually enable bilateral decision making on patenting rather than, say, a unilateral imposition of standards by the US or unilateral pressure being put by the US. Do you actually buy this argument, or do you think that the fact that US, as you've already sort of hinted towards, the fact that the US will be involved in decision making on our laws is a violation of our sovereign rights?
Well, the DIPP has been talking in different voices, which I guess, reflects in a way the fact that there is still no absolute consensus even within the bureaucracy and the government in the requirement to change India's laws. So the DIPP, in fact, initially also said that we already have an existing trade forum with the US since 2010, which provides a space for discussions of this kind. But the DIPP has also now said that this kind of a group is innocuous. So it's obviously speaking in two voices. The DIPP has also circulated a paper where one of the things that it says in that is that while developed countries have high standards of IP, we are now seeing a lot of developing countries changing IP legislation or IP practice, which are in sync with high IP standards followed by developed countries, thereby signaling that India should also be doing that because correct? Everybody is doing that. It's not correct at all. I mean, in fact, the interest in many countries such as say Brazil or Latin American countries, even some Asian countries such as Thailand, has been to try to see how they can mitigate the impact of high IP standards. In fact, they now regret that unlike India, they did not make use of the 10-year period, transition period after the TRIPS agreement was signed. They changed their IP laws too soon. There was not enough thought given into how those IP laws would incorporate the flexibilities, and so there is an interest in actually the reverse direction in many countries. But it's also true that because of the pressure by the EU and the US, especially led by the free trade agreements, not so much the WTO, that countries are being pressured into having sort of legislations in place which have higher standards of protection, but that is by no means a reflection of their actual intent or willingness, but rather a reflection of the kind of pressures that they, and especially bilateral pressures that the EU and the US is now bringing to bear through the various free trade agreements.
Now, again, as you mentioned, I mean, given the tremendous pressure which is actually being put on the US, on our government, I mean, so we've had India placed on a priority watch list, we've had an out-of-turn review of our IP regime. Do you think that the working group can actually be used in our benefit in any way?
See, anything can happen depending on what the parties want to make of it. Now, we know what the US wants out of it. Right? The point is, what does India want? That is going to determine what the working group is going to do. And there are again disturbing signals regarding India's intentions. So that for me is more important rather than TOR and stuff like that. So you have, for example, Arvind Subramaniam, who is today the chief economic advisor to the Indian government. He, as a private citizen in the US, had in fact given an opinion to the US House, an expert opinion saying that there is a strong case for the US to take India to the WTO court because of violation of the TRIPS agreement, specifically related to the to Section 3D.
Right.
So, so you have people like this who are now constructing policy.
Well, that's all the time we have today, Amit. Thanks for joining us. This is clearly an important issue and something that we'll keep an eye on in the future as well.
Thank you.
Thank you for watching.